of that cohabitation. For instance, in relation to your right to reside together. Second, bank accounts, insurance policies. These are practical issues which can be resolved by the government. From your perspective also, this is a step forward.
Absolutely.
You see, therefore,
For example,
therefore said you don't have to go for all or nothing approach.
for example, two persons, two old men are staying together. They are not necessarily in any gay relationship. For companionship, for looking after each other, etc.
That analogy misses the point. It does not take an assertion of rights for two adults who are self-sufficient to live together. That is an exercise of free will. Rights is a proactive, positive enactment that the law recognizes. There is a distinction here. So an old man being taken care of by a caregiver misses the point.
No, but that's
No, not caregiver. Two people, three
that-
people
that-
staying
that is
together,
just
they
given
want to
example.
share their bank accounts, their insurance.
We are not. We are talking
See whether
specifically of same-sex
it's a
relationships.
caregiver taking care of a person under his care, or one who is being cared. He is neglected by his sons, he is neglected by his children or other relatives. He does not want to give it to them. Now, short of creating a will, in case he dies intestate, if he has a nomination, he cannot nominate this. See, today
Be a part of, say, medical insurance. He wants to be
bow
a
down
part
this,
of medical insurance.
But may I just say this, for something as simple as pension, provident fund, gratuity, benefits, that accrues only in a marriage. It does not accrue to the caregiver. What accrues to the
That
caregiver,
accrues in a
even in
marriage,
other
but Dr.
systems?
Goswami,
That's the
that
reason why
accrues-
one is putting forward this
Exactly.
idea.
Yes, my lord.
And that accrues in a marriage because of the nature of our rules.
Correct. Well, it's
If you
very
have to,
unstable.
therefore, that's something exactly which the government has to consider.
Well,
And that's
that's
why
what
we
we-
thought.
Suppose hypothetically, I do not know, my lord, what will be the implication. My lord, suppose the government says that nomination in case of provident fund would be a family member or anyone else which the retiring person chooses to. No, then you don't need to go into anything else, my lord, the problem is solved.
Let us be clear.
So
Just one
sometimes
second.
solutions are, my lord, simpler than the problems.
Well,
See,
to
Dr.
be
Singhvi-
clear, to be clear, when Justice Paul is saying.
Once again,
Justice
Justice
Paul is-
Paul wants to say something.
Dr. Singhvi, please notice, as my brother colleague said, this is without prejudice to everybody's rights and contention. One. Number two, even if the court was to, suppose you were to succeed to a limited extent and the court was inclined to give you a status of a marriage or inclined to give you a status of some other status, let us say not marriage, but some other status, there'll be many changes required in administrative proceedings as also legislative aspects. Therefore, if there is a consensus, at least whatever be the status recognized, after all, they are not denying that this is an incidence of society which is happening. They are reluctant to give it a status of marriage, but they are not, I believe from what solicitor says, reluctant to sort out the problems arising from a gay companionship without labeling it as marriage to the extent possible. Now,
May I respond just one
It's
second?
not gay.
I
There
want-
are several combinations I don't wish to
No,
go into.
Mr. Solicitor, let the
It
learned
becomes
judge-
unmanageable, my lord, to
complete.
fathom
See, let me-
the
let
possible
judge finish.
combinations, my lord, which can arise.
let the learned
Let me
judge-
complete, Dr. Singhvi. Let
All
me
is saying.
complete. Yes. Therefore, what is the suggestion from the bench is that the nitty-gritties of what may in any case be required to be done in either situations, some endeavor or step is taken in that direction. I think that's what Justice Bhatt and the Chief Justice put. So
Well,
I think let us, without prejudice to anything else,
Absolutely.
sit with pre-notions or prejudice notions on either side as to what
Well,
can be sorted.
I
Without
start with
prejudice
that.
to both the contentions. My
Mr.
contention-
Solicitor, 1 minute, please. Whereas I start with that, give me just 2 minutes. Your lordship may take it. I started with that. And I'll do better, Wallace. I'll try and make a chart, which is actually 3 categories.
Right.
And a 4th is, Wallace, conceptual. Give me just 1 minute. One category, clearly, possibly solvable immediately, is the so-called administrative tweaking, which is followed from my lord, Justice Bhatt, Justice Kaul just now. Surely what you can get by easy tweaking,
There is no question of looking a gift horse in the mouth for no reason at all, just because we are on some principle. Of course, it should be cooperating. Of course, we'll give that. A second category may be something more than that. A third category may be substantive, bigger changes. I'll try and identify them separately. But above all these three, so the first category, Lordship, take it. People will meet up, people will make a list, people will share it with the solicitor. We have no problem, we have no ego about it. The fourth idea is important for Lordships, and only your Lordships can decide it. That is the real, the symbolic, the actual meaning of marriage. That nobody can decide except this court, this way or that way. No committee, no circular, nothing can. Now that's the juristic question. 1 second, Mr. Solicitor, 1 second. That's the juristic question. Now, therefore, we are, as Justice Kaul said, we are happy to divide it, and what might be called low-hanging fruit.
Yeah.
Benefits everybody, everybody eats that fruit. Of course, we'll cooperate. The other fruit will have to depend on some kind of an order. And we'll make that categorization to the best of our ability.
Equally, Dr. Singhvi, when we go into the conceptual domain,
yes,
we cannot be oblivious of the fact that to the extent to which the conceptual domain requires legislative changes, that part clearly lies outside the limit of the court.
That will be part of the dialectics.
Then the question which the court will have to face is, to what extent does the court go in formulating conceptual doctrine?
Yes,
absolutely.
Because ultimately, whatever doctrine the court formulates has to be relevant on the ground. All right? Therefore, there may be three levels, really. There may be certain areas which are governed by pure administrative, changes.
That's what
can easily be done by them. Second, changes which they accept as a matter of principle, which may require changes in some form of subordinate regulation. Which again is a matter for the government. They don't have to go to parliament for that. Which is again much easier to achieve than, say, a parliamentary change in legislation. The third is your wider, your widest case. Your fundamental point is that, well, there is a right to marry, one, with reference to constitutional precepts, even for same-sex couples. Second, that you can found that or source it in the Special Marriage Act.
It's not a hollow right, it's not just a shell.
That's what you have all argued. That is what you have all argued. That's something which we will have to ultimately decide, subject, and therefore that's what their argument is.
That's all that I'm saying.
That this is essentially a legislative arena, don't step into this.
Dr. Singhvi, yes.
Therefore, we are saying that, well, we will of course have to decide it. We are going to decide this entire issue as a matter of concept. But to the extent to which the government takes the first step forward, there would be a substantial benefit, a substantial advancement in the recognition of the cohabitational relationship of same-sex couples in the country today, which would be a substantial advance beyond what we have today.
Yes. I certainly have no such.
Exactly the point. I would put it like this, somewhat like this, a bit differently, which is that Dr. Guruswamy and I think Mr. Kripal, all of you in different ways said that, this could be a part of a series.
Part of a
series, whatever you want. Look at it from the reverse. If this results in a gain, maybe not as substantial as you visualized, right? That's one of the building blocks for your future, No, do you want a ruling then? That too is something you may have to consider, given that you're now not really fighting a battle only for these petitioners, but there's a larger group of people who may not be covered by this dialectic of Special Marriage Act. So then, is it advisable or prudent, if you're going to get this, to continue with that larger push?
We'll build that into our argument. We'll reflect on that and build that into our argument. We'll fully understand what my lord is saying. Fully understand.
Can I say one thing?
Only one request I would make.
People who are not in that part of the dialectic. Because we've all gone and spoken on in seminars, and there are people who believe in the absence of heteronormative institution of marriage. And when one goes out and meets 99% of the people who come up to you, they all say only one thing, that they want to get married.
yes.
Because the consensus within the community, no matter how many people may say that it is a concept that they otherwise reject, is that they wish to have marriage.
Yes.
Because this gives meaning, purpose, identity to the people who are seeking to get married. Because and my learned friend will agree with me. So it's not correct to say that there will be people who will be out of the bound of marriage, who don't want marriage, but they are happy with something else. I, personally, and I'm sure Ms. Guruswamy and Ms. Grover as well, In all the multiple meetings we've had,
Yes.
we hold some academic discussions of
Yes.
people who say, no, it's a heteronormative institution, it's not necessary. The vast majority of the young people I have spoken to
Yes.
have all said, we want to get married. The parents of those young people have said, we want to get married. Because we say we want to get married. Why should we be second-class citizens? Because there was a time we were criminals, then we became third-class citizens. Now they're saying be second-class citizens, then be content. That is not what the Constitution promises.
Yes.
So that's the third category. Well, I'm not belittling your lordship's first or possibly second category. Please don't misunderstand that. All of us here, but we are all imploring your lordships to recognize a third category, incapable of partial minimal resolution by the Solicitor General.
Just
Incapable. But the first or the second, yes, we'll fully cooperate.
And one exercise we also undertake.
my lord,
And we'll
just-
keep
but I
listening.
just-
But fellows,
Yes.
that point in mind, that whether we can give up something, not give up, that part, I understand.
And ultimately,
No, in the sense, Madhu, that it can be tailored. No, for us, tailored.
My lord,
Can I
but
suggest also,
just
we amongst ourselves, all the petitioners are sitting down and we are trying to make some kind of a draft of what is it that we can hope to achieve. So there's a consensus in ourselves. We understand we can't get everything. Because we will put forward some idea of what is it that we hope that this court can give
that's
us.
exactly why we thought that some
Well,
sort of
that's
meeting of
our
some
concept.
exchange of ideas between all of you would be helpful.
Consensus is amongst us already that at least Section 4 recognition of marriage has to be given. What rights follow from that, when, how, those modalities.
Yes.
So that is legislative. My lord, therefore, my lord, I would request.
May I just say this, my Lord Justice Bhatt? When I speak at different events around this country, I make it a point to speak in small towns India. And I make it a point, and young people in our country want marriage. I don't say this as an elite lawyer. I say this having met these young people. Do not let them experience what we have experienced. Every study indicates that in countries where there's marriage equality.
On the marriage.
Dr. Guruswamy, there's a problem with this line of argument.
No.
I'll tell you why. We understand the feelings out of which this argument comes. But at the constitutional level, there's a serious problem. If we go by what young people feel as a constitutional court, then we would be subject to volumes and tomes of data on what other people feel. Now, therefore, the great salutary safeguard of constitutional adjudication is that the court has to go by what the Constitution mandates.
Correct.
And therefore, we don't go by
Yes.
either popular morality or a segmental morality. We decide what the Constitution says.
But this is
Because the moment you say that this is what young people feel, I'm sure there'll be people on the other side who are willing to throw tomes of material at us on what the country feels.
it's my only.
Let's not get into it at all.
My lords, this.
Therefore, what we were suggesting was this. We get your point that you seek a right to marry. You are also conscious of the fact that a mere declaration of a right to marry is not adequate in itself unless it is implemented by a statutory provision which recognizes, regulates, confers entitlements on those who are married. Therefore, you are conscious of the fact that the implementation of the right, the achievement of progress on the ground depends on whether there is a statutory framework for implementing that right. And therefore, you say located in Section 4. We'll consider that argument. But as we said, suppose we were to come to the conclusion that this argument is not as simple as it appears to be, that there are too many interlinkages with other statutes, including personal law, which we would be treading upon, and perhaps which would lie outside the domain of judicial review. Then what? Then our concern is that, look, everything has to be something which you achieve in incremental steps. This is a social institution. That social institution is also evolving over a period of time. But the court can ensure, by acting as a facilitator, that real progress is achieved today in terms of a wider societal acceptance of the right to cohabit together. Whether we go as far as to recognize the right to marry for couples who are not heterosexual couples is a separate matter. We'll be dealing with that. We are not shutting the argument to you. That's why we are hearing this side. But even assuming that we don't, we do, that's the end of the matter. But if we don't want you to be in a situation, or the movement to be in a situation where there's nothing else then available in hand, that this matter then goes. That's not the way we are couching this dialogue.
See, if you've seen the history, and I think this side, you're all acutely aware of the history, you know better. You've seen the ups and downs of that for the last half century and where it went to, what kind of legislation came, not positive, mostly negative, and how finally you got the judgment that the US Supreme Court gave. Now you are circumventing all that. Of course, there is a lot of, let's say, feeling in this, a lot of felt, experiences in those. Nobody is discounting